appeal, which was filed after a delay of 24 days. He submits that the delay is unintentional, which may kindly be controlled. After hearing the concept of the appeal to the respondent, I find that sufficient ground has been shown to control the delay. Delay control. Full stop. List. Yes. Why do you want to stay, Mr. Ashutosh Anand? Unmute yourself.
And we had looked at
19 lakhs, 10,000.
the claim of the claimant was that he was running a grocery shop and he had made certain investments. The learned tribunal, without making any assessment with vis-a-vis the assessments are concerned or the bank passbook,
Place this case under the heading for admission along with the IA number 1345 of 2022. Uh, after 1 week?
my lord,
After 1 week.
My lord, if they because my lord, it can be there is no right of recovery. So if it is possible, it can be settled if they agree, my lord.
definitely, my lord. We can take an endeavor in the Lok Adat even, my lords.
Okay. Both the parties submit that the matter can be referred to the Lok Adalat. As the insurance company has challenged the quantum and the claimant has filed for an advance.
My lord,
My lords.
Considering the submission, the matter referred to Lok Adalat.
oblige, my lord.
Both.
My lords.
Both the appeals referred to National Lok Adalat. There are two possible in order matter. Possible matters under the heading for order. Number 4, number 283 of 50, Mr. DC goes for the appellant, Mr. Arvind Kumar Lal for the respondent. Yes, Mr. Ghosh.
My lord, in this appeal, I have filed an application praying for substituted service of notice upon respond number 3 and 4. My prayer may be allowed, my lord.
Why, in spite of issuance of notice, they have not appeared.
No, therefore, my lord, on the last occasion on 27/10/2001, a direction has been given upon the present appellant to take steps for paper publication. Therefore, I have filed an application.
Where is that application?
Application filed on 21/2/2022, 21 March,
Is it on
21
the
February.
Just check it. Just a minute, let my office check
My lord.
the records. You filed it on 21st of February.
G. 21st February. Because on 7th February, 3 weeks time was granted. Thereafter, I filed.
Is it there? Filed? No, you have not filed most probably. The computer is not showing any entry about filing.
Yeah, file. And I have then I have whatever I will check it up, my lord. Then हम तो फाइल किए हैं हुजूर मेरे सामने, लेकिन हम देख लेंगे हुजूर, तो देख लेंगे हुजूर.
On the request of Mr. DC Bose, this case is adjourned for 2 weeks.
My lord, हम देख लेंगे.
My presence may kindly be recorded. My lord.
Mr. Arvind Lal is present.
Figure number 5, MA number 334 of 50, Mr. Lakhan Chandra Roy, for appellant, Mr. Alok Lal for the respondent.
Well, in that case, well, the copy of the award has not been served upon me. Perhaps it seems to be appeal is by the owner.
Where is Mr. Lakhan Chandra Roy? In the second round also, no one appears on behalf of the appellants. This case is thus adjourned for 4 weeks.
Under the heading for admission, serial number 22, MA number 30 of 16, Mr. Alok Lal for appellant, Mr. Ramit Satendra, Mr. P. Sita Singh, Mr. Rakesh Kumar Sinha, Mr. Rajesh Kumar Singh for respondent.
Pursuant to notice minutes, I have appeared on behalf of respondent number 2 and filed my power minutes.
Yes, Mr. Lal, what is the dispute?
Well, this is an appeal. A very short issue is involved in this case. This is a case of injury. Now, one thing which would be apparent that in this case, no medical witness has been examined to assess the injury. Now, in this case, very significant thing is that in this case, the learned tribunal has come to a finding that the owner has violated the terms and condition of the policy, but the right of recovery part has not been given in the operative part. That is the only issue in this case, so far I am concerned. That would be in paragraph 9. Paragraph 5 is my defense.
So where did the court held in which paragraph that you are entitled for right to recovery?
Yes, paragraph 9. Now I take up issue number 3, whether the vehicle was insured with OP Insurance Company at the time of accident and whether there is a violation in terms and condition of the insurance policy, including requirement of valid driving license. In this case, on behalf of the insurance company, one witness, namely Vishwajit Mukherjee, has been examined. This witness has not stated anything regarding the absence of insurance policy. There is no specific denial of the insurance policy, even if in show cause. So I find that at the time of accident, the above mentioned tanker was insured with OP Insurance Company. So far, violation of terms and conditions of the insurance policy is concerned, as per OP witness Vishwajit Mukherjee, at the time of accident, the driver of the tanker was not having a valid driving license. There was no road permit for flying the tanker within Jharkhand. On behalf of OP number 2, OP Insurance Company, driving license driver tanker Surendra Rai has been marked Exhibit D and Exhibit E. The permit issued by RTO Hooghly from perusal of Exhibit E transpires that the permit was valid only for West Bengal, excluding hilly portion of Darjeeling.
Why have you filed an appeal for this? Why couldn't you file an application under 152 of the CPC?
Since the order has been passed, therefore, my lord,
Yes, you come to 152 of the CPC. What does it say? Because paragraph 9 is quite clear. It's a finding and there's a direction that I find there is a violation. Accordingly, OP Insurance Company is entitled for recovery right after payment of the compensation to the claimant. This is finding. So now you come to 152. Switch on your microphone. For this, you prefer an appeal.
CPC. But it says about clerical or arithmetical
Right?
mistakes.
Read the full. Don't go on the heading.
Clerical or arithmetical mistakes in the judgment, decree, or orders, errors arising therein from
Or
any accidental
what?
slip.
Or why are you skipping the
Yes,
word
or
or?
omission at any time may be corrected by the such court either of its own motion or on the application of
So
the party.
so 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 what is it? Clerical or arithmetical mistakes in the judgment. This is one judgment and degrees. This is one part. Or orders or errors arising therein from any accidental slip or omission.
But in this case, one would kindly see the operative part.
So it's an accidental omission. In view of the last line of paragraph 10, last
12.
sentence.
Yes.
So not mentioning this in the award is an accidental omission. Is it not, Mr. Lal?
Well, it's subject to my understanding, it is not.
Then what is it?
It
Then
is
what is it?
the the operative part of the decree. Operative part, the
What is it? If it is not an accidental part, then what is the finding? What is this decision? Accordingly, OP number 1 is entitled for recovery, then that is an accidental part or what? Is it not an? Does it not cover
But-
under 152?
but it can't, but I am not sure about it. I cannot say because this is the part which has been. It can be said it has been omitted, but the thing is that the
Is it
court
a deliberate omission or an accidental omission?
maybe an accidental omission, maybe an accidental omission.
Then it comes under 152. You file an application under 152 for that you have filed this appeal unnecessarily.
But there are several cases of this nature coming before your lordships.
No. So unnecessary it is coming before this courts.
As because the Dollar Tribunal, in number of cases, word adds word if entitled, if pay.
No. Stick to this case only. There is not if entitled. There is clear finding. There is a clear finding and a direction given while deciding issue number 3.
But subject to my correction, my lord, after such a long period, the annulled court, unless and until there is some direction by your lordship,
Why should I? Why have you filed this?
because my interest, because if my lord feels that this appeal is not maintainably dismissed, then the learned court below will not interfere in it.
No. This appeal is not maintainable in view of section 152.
Then in that case, my lord, the learned court below will not interfere. This is my understanding of law. This is my
Why?
submission.
No.
Certainly, my lord, certainly, because they say that the learned court, or honorable court, has not exercised its jurisdiction. That how should I then?
So 152 jurisdiction is with me. A tribunal pass an order with an omission and you will say that I will exercise 152.
Unless and until that correction is some observation is given by your lordship.
What observation? What observation? This
That if it is an accidental slip, the appropriate forum would have been to make an application. Unless until that observation is made, the lower court will not entertain my application. They will never entertain my application.
The counsel for the appellant, this appeal is being disposed of at this stage itself in view of the considering the nature of the ground.
That will complicate the issue, your lordship, again.
No, never. Let's see. Okay. Next, but the counsel for the appellant has raised only one point in this appeal at the time of argument. He submits that while deciding issue number 3, the tribunal has already passed an order that the OP insurance company is entitled to entitled for recovery rights after payment of compensation to the claimants. He submits that the tribunal thereafter in the award while passing the final in paragraph 12 has inadvertently failed to incorporate the aforesaid direction in the award portion, in the order portion. he submits that this inadvertent error may be corrected and the right of recovery may be given to the insurance company. Next paragraph. Mr. Ramit Satandar appears on behalf of the owner of the vehicle. You have not filed any appeal. No appeal has been filed. No appeal has been filed against the. He submits that no appeal has been filed against the judgment and the award. Full stop. Next paragraph. After going through, after hearing the submission of Mr. Alok Lal, the counsel appearing for the insurance company, and the issue which he has raised in this appeal, this court is of the opinion that this court is of the opinion that a petition under section 152 of the CPC before the tribunal could have resolved the issue rather than approaching this court by filing this appeal. Next paragraph. First paragraph. Next paragraph. The issue number 3 was decided by the tribunal, and the last line of issue number 3 is as follows. Quote kar dijiyega. So I find it. First. The aforesaid finding was arrived at, aforesaid finding and the direction was given since the tribunal has concluded that there was a violation of the policy. This direction and finding clearly suggests that the right to recovery was given to the insurance company to recover the amounts. But due to inadvertence in the paragraph 12, the same was not incorporated. The same direction was not incorporated. Next one. Section 152 of the CPC provides for amendment of judgment, degrees or orders. It is necessary to quote section 152 of the CPC. From the aforesaid provision of law, it is clear that an order, if there is an accidental slip or omission in the order, from the aforesaid provision of law, it is clear that if there is any order, any error which arises from any accidental slip or omission, the same may be corrected by resorting to section 152 of the CPC. In this case, it is the case of the appellant. The learned counsel for the appellant submits that the error is accidental. Considering the nature of dispute, considering the aforesaid fact, this court is of the opinion that the petitioner, the appellant should have filed a petition under section 152 of the CPC before the tribunal and prayed for correcting the error which arose from accidental slip or omission in the award dated 6th October 2015, passed in compensation case number 211 of 13 by District Judge 3 Jamshedpur. Thus, this appeal is disposed of with the liberty to the appellant. Thus, as per this court, this appeal is not maintainable. Liberty is granted to the insurance company to file an appropriate application under section 152 of the CPC before the tribunal.
For the statutory amount?
The statutory amount, you have wasted the time of the court, it should be forfeited. By unnecessary filing this appeal.
It should be returned to the insurance company.
It should be forfeited.
No.
Why did you file an appeal in view of specific
because the
provision?
error has not been committed by us.
No. Mr. Counsel, you read 152, the court can suo moto or on an application.
Well, that would be something very...
No, you should have approached 152, then you could have filed an appeal. The court has not accepted
So that
this.
my submission may be noted that the statutory amount I am paid for the refund is certain what it has been
The statutory amount be refunded to the insurance company. It should have been forfeited as cost.
जो
Yes.
रिटर्न होता है उसमें तो इंटरेस्ट होना चाहिए लाओ वाला तो
Disposed of. Go and file a 152 application. Yes, next.
Serial number 23, MA number 139 of 16, Mr. Sachidanand Lal, Mr. Dr. Aslan Waris, Mr. Rajiv Anand for appellant, Mr. Alok Lal, Mr. Vijay Kumar Sinha for respondent.
Yes, Mr. Waris.
My lords, pursuant to your lordship order, I have been appointed as an advocate, my lords, for the appellants, my lords. I have filed Vakaratnama. I pray for the copy of the records, my lords.
Office, Mr. Uh, Learned Counsel, Mr. H. Waris,
My lords.
has been appointed by Jalsa,
My lords, my lord.
by Jalsa to represent the claimants. Full stop. Next para. Claimants, comma, pursuant to the order dated 20 July 2020.
My lords.
Next para. The office is directed to serve a copy of the entire brief to
My
Mr.
lord.
Waris. Entire file to Mr. Waris. Is this case after 3 weeks?
My lords, my lords. My lords.
Serial number 24, MA number 146 of 16, Mr. Rajesh Kumar, Ms. Jaswinder Majumdar for appellant, Mr. Ramchandra Sahu for respondent.
Your Lordship, I am appearing in this case, Your Lordship.
Yes, what is this?
This appeal is against the order dated 12th of January 2016, Your Lordship, where the application for grant of letter of administration has been dismissed by the London Court below. Now, this appellant, Your Lordship, he is the although stepbrother of the deceased, Your Lordship. This and the deceased, Your Lordship. Deceased was having no child, Your Lordship.
Read the judgments.
Yes, Your Lordship. Page 16, Your Lordship. Because the lower court. The case of the applicant is that Ravi Mahato, since deceased, is a Hindu and he died on 15th of September 2005 at Sitalpur, residing at Sitalpur PO, Gharwar PS, Baliapur district, Dhanbad, and ordinarily resided at Sitalpur PO, Gharwar PS, Baliapur district, Dhanbad, Jharkhand, which was his fixed place. The deceased, while in sound health and perfect stage of mind, had executed his last will and testament on 2nd of September 2005, and he left and bequeathed his estate and effects thereof in favor of his applicant as the sole executor of his last will and testament. That is the registered will number 3-26 dated 2nd of September 2005, registered in Sub-Registry Office, Dhanbad. The last will and testament of the said deceased was duly executed by the deceased on 2nd of September 2005 in presence of the attesting witnesses, and the said will is duly attested by the notary public. One of the attesting witness, namely Bhim Mahato, who sworn affidavit along with this application. The deceased has left behind him the following persons as the nearest relatives, who are the opposite party number one is the wife, Your Lordship, the second wife. Madhu Mahato, wife, address village Budhia P.O. so and so. Satish Mahato, son of late Madhu Mahato, brother. He's also stepmother, brother, Your Lordship. And Sadev Mahato. Sadev Mahato is the appellant before Your Lordship. So Sadev and Satish are the step brothers, Your Lordship. And Sadev Mahato, who is the appellant before Your Lordship. The petitioner applicant has duly set forth in Annexure A and here to bring the affidavit of assets affirmed by the petitioner applicant, showing valuation of all the properties and credits who is the deceased died possessed of or was otherwise entitled to at the time of his death, which is are likely to come in the petitioner's applicant's hand. And so far as the applicant has been able to ascertain or is aware or there are no property and credit other than what are specified in the affidavit of assets annexed hereto. The value of the assets which are likely to come in the hands of the executor petitioner, as set out in the affidavit of the assets in the event of probate of the will, being granted in favor, does not exceed in the aggregate the sum of rupees 50,000. The petitioner applicant shall pay the duly money payable for the grant of probate in respect of the assets duly in the Schedule A below. No application has been made in the High Court or other district court for probate of the said will or for letter of administration of the said estate. The petitioner applicant undertakes to duly administer the profit and credits of the deceased and to make a full and correct inventory thereof within 6 months from the date of the grant of probate to the petitioner, and also to render and correct account of the properties to this learned court. Now, the schedule of the property schedule is, Your Lordship, within the district Dhanbad PS Baliyapur, entire come lying with SBI, entire sum lying with SBI. Sindri is having saving account number with interest if any. Second is the plot Sitalpur Moja plot number so and so, 35 decimal 1 katta and 48 decimal. Then Bir Singhpur Moja plot number so and so, area 59 decimal. Total area 1 acre, 42 decimal. Out of 33 decimal is paid for the applicant to the share of the deceased. There is no impediment under Section 370 of the Act for grant of letter of administration to the estate of the deceased. The opposite parties have appeared and filed their show cause written statement. Objection stating that the person that the present case is based on entirely false statements and the so-called will is forged, created, and manufactured document. It further submits that the present case has been filed with the malified intention to usurp the properties left behind by late Ravi Mahato, depriving the opposite party number one, who being close here is alone entitled to the estate of late Ravi Mahato. It also contains that the avarice of the applicant went to such an extent that he did not hesitate to get a document purported to be will created manufactured just about 10-15 days prior to the death of the Ravi Mahato. While the Ravi Mahato, having taken leave from all his senses, was lying in a dying state. The statement made in para 1 and 2 of the application are more or less correct. It further contains that the statement made in para 3 of the plaint application are maliciously false and are fraught with mischief. And to reply to the averments made in para 3, it is essential to state few facts which are as follows. The deceased Ravi Mahato was an employee of ISCO and Unit of Steel Authority of India Limited and has retired from his services on 31st of July 2004. On his retirement, he had received a handsome amount of money as his retirement benefits and deposited the same with State Bank of India's Sindri branch, where Ravi Mahato was having a saving account, being saving account number so and so. And entire retired benefits amount to rupees 5,34,964.76 paisa was deposited with the SBI. Sindri by Shri late Ravi Mahato. And Ravi Mahato, being a literate person, used to withdraw money from the said account and by signing the withdrawal instruments. Ravi Mahato family, of which he was the duly earning member, comprised of his wife Mandu Mahantain, who is the opposite party number one, and his brother Sadev Mahato, applicant, and the Stish Mahato, who is the opposite party number two in this. She said Ravi Mahato, however, felt critically ill, so much so that the nerves of his brain became so adversely affected that he became paralytic, and as such, he was not in a position to operate the account. But as the family members had no other source of income, and as Ravi Mahato was unable to do any act, having been almost in a state coma, the family members of Ravi Mahato approached SBI Sandra with the request to permit them to withdraw some money from the account of Ravi Mahato on the basis of thumb impression of the Ravi Mahato on withdrawal instrument. But the said bank turned down the request, whereupon a complaint case being consumer case number was caused to be filed by Sadev Mahato on behalf of the Ravi Mahato. Sadev Mahato, being the oldest member of the family, was looking after and managing all affairs of the family. When Ravi Mahato, owing to his severe illness, had been in vegetable state or almost in a state of near coma. Obviously, no other members of the family had any reason to disbelieve the bona fide of the applicant in managing affairs of the family, especially the retired benefit money of the Ravi Mahato. And it was a Sade Mahato who was dealing with the SBI Sindri as well as looking after the consumer case relating to the money lying in the said bank. For the purpose of managing the aforesaid retired money of the Ravi Mahato, lying in SBI, Sade Mahato obtained his thumb impression of Ravi Mahato, who having been in near coma state of health, had no senses, saying that those thumb impressions are required for the purpose of making correspondence with the bank, as well as filing petition, etc., before consumer forum in connection with the above consumer case. Then one morning, that is on 2nd of September 2005, applicant told the opposite party that in order to get some money from the bank account of SBI Sindhi, it was essential to take Ravi Mahato to the consumer court and or SBI Sindhi to show that at least Ravi Mahato was alive, notwithstanding the fact that physically Ravi Mahato was a vegetative or near coma state, and nobody, including the opposite party, had any reason to disbelieve the applicant. More so when the applicant stated that two of his acquaintances, including a co-villager, Chandicharan Pal, were accompanying him and Ravi Mahato. As the days of Ravi Mahato were numbered and he was certain to die, after all the nerves of his brain were damaged in May 2005. So when Ravi Mahato died on 15/9/2005, it was predictable and every member of the family, including his wife, mourned the death, performing all ceremonies and rituals. Thereafter, Manu Mahatai, opposite party number one, started making preparation to collect all the debts of Ravi Mahato, including the aforesaid money lying in the account of Ravi Mahato with SBI Sindhi, as well as money lying in a joint account standing in the joint name of Ravi Mahato and his wife, Mandu Mahatai, that is opposite party number one with Saturday Cooperative Bank. Dhanbad. And she had no problem in collecting the money from the cooperative bank Dhanbad. But as the total credit balance in the aforesaid saving account with SBI Sindhi was pretty big, so she was advised to obtain succession certificate. Moreover, she was informed by SBI Sindhi that applicant Sadeh Mahato was claiming the money lying in Ravi Mahato's account on the basis of a will. Thereupon, she filed a succession case number 53 of 2006, implementing Sadeh Mahato, Stish Mahato, as well as sons of Sadeh Mahato and branch manager SBI Sindri as the opposite party in the said case. Sadeh Mahato appeared before the court of Sub-Judge 1 Dhanbad and filed his show cause in connection with succession case number 53 of 2006. And his show cause, Sadeh Mahato took the plea that Ravi Mahato executed a will bequeathing the money lying in the SBI Sindri to him, and he had filed a probate case, being probate case number 5 of 2001 2006, before the district judge Dhanbad. The inquiry of the present opposite party revealed that the probate case 5 of 2006 has been dismissed for non-prosecution and suppressing the said fact, Sadhem Mahato filed a fresh case number probate case number 6 of 2006 before the district judge Dhanbad, which has later been transferred to the court of additional district judge, fast track court Dhanbad. From the inspection of the will annexed with the probate application, it became evident that the said will is an invalid, illegal, and void document for the reason that the testator indisputably was not in his disposing state of mind. Rather, physically, he was a vegetable or near coma stage, with the nerves of his brain and mental faculty were so badly damaged that the testator could neither comprehend or speak anything. So, notwithstanding the fact that his thumb impression might have been taken on some paper, he must not have understood the contents, the purports, and implication of the documents on which his thumb impression was being taken. Other than the fact that the complainant was mentally and physically so severely deficient so as to do any work which requires slightest of mental exercise, the contents of the will itself is surrounded a lot of suspicious circumstances, like by the so-called will entire money lying with the SBA was allegedly bequeathed to the applicant, excluding the wife and another brother of the testator. But no reason for such exclusion has been assigned. Under normal circumstances, a testator shall not exclude any of the legal heirs or dependents, especially his wife and own brother, that is Tish Mato, unless cogent reason is assigned to the will. But in the purported will dated 2nd of September 2006, no reason has been assigned for exclusion of these opposite party, which is rather surprising for the reason that the money lying in SBI Sindri constitute 90% of the total fund available with the family. There was absolutely no reason for the testator not to take his wife and brother, Stish Mahato, to the office of sub-registry for the purpose of execution of the will if he had bona fide intention to do so. There is another strong suspicious circumstance. Furthermore, when this opposite party met Chandi Charan Pal, one of the attesting witnesses and a co-villager of the party here too, said Chandi Charan Pal confided in this opposite party that the applicant did not let Shri Pal to know anything about the contents and the nature of the document so-called bill, on which his signature was obtained. Rather, Sadhem Mato, the applicant, misrepresented to him that certain documents was needed to be executed so as to ensure the money locked up to the in the SBI Sindhi could be withdrawn by Magdu Mahantine for the benefit of the whole family. Although, Your Lordship, this Chandi Charan Pal could not be examined because he died. Another attesting witness, namely Bhimlal Mato, who has been examined on behalf of the appellant, Your Lordship, though not the resident of the village where Ravi Mahato used to live, that is village Sitalpur, and the said witness, apart from being a close acquaintance and the distant relative of Sadeh Mahato, when contacted by the opposite party, too admitted that his signature too was obtained on the so-called will through misrepresentation, fraud, and deception. In view of the above fact circumstances, especially suspicious circumstances, it is evident that the purported bill dated 2nd of September 2005 is void, illegal, inoperative, fraudulent, and no probate of the same can be granted. Now, the fact that the so-called will dated 2nd of September 2005 was drafted in English, notwithstanding the fact that neither Ravi Mahato nor any of the attesting witnesses had even smattering of knowledge of English language. Rather, all of them were pretty conversant with Hindi. In another suspicious circumstances, for the simple reason that the applicant wanted to ensure that nobody, including attested witnesses, could comprehend the purport, nature, and implication of the so-called will. That the statement made in para 4 of the probate application is maliciously false, as the documents annexed with the probate application is not the will executed by the testator Ravi Mahato, for the reasons stated in the foregoing paragraphs. That the statement made in para 5 of the application are more or less correct. That the statement made in paragraph 7 to 9, the application are false, incorrect, misconceived, and unsustainable in the facts and law, for the reason that Ravi Mahato never executed the so-called will dated 2nd of September 2005 for the reasons stated in the foregoing paragraphs. That the statement made in para 10 of the application is meticulously false because the applicant petitioner Sadem Mato filed an application probate before District Dhanbad, which was registered as probate case number 5 of 2006, but the same was dismissed for default, and no attempt has been made to restore the said probate case. Thus, the present probate case is barred under Order 9, Rule 9 of the CPC, and that, apart from petitioner Sadeh Mato, is guilty of suppressing a material fact, and on that score alone, the present probate case is liable to dismiss. That the statement made in para 11 of the application is incorrect and misconceived for the reasons stated hereinafter, and hence denied. That in view of the facts and circumstances, the petitioner applicant is not entitled to the probate of the so-called will dated 2nd of September 2005. And on the contrary, the petitioner applicant is liable to be prosecuted for creating fake will and should be visited with exemplary costs. In view of the liable submissions as made by the applicant and opposite party, following issues have arisen for determination of the case. Whether the testator Ravi Mahato was in disposing state of sound mind at the time of the execution of the will dated 2nd of September 2005 in favor of Sadhem Mahato. Whether the will dated 2nd of September 2005 is true, genuine, and duly attested. whether the applicant is entitled for grant of letter of administration as previously. Issue number findings. Issue number 1 and 2. These findings are these issues are main issues for determination of the case. The applicant has altogether examined two witnesses in support of his case, who are AW1 Bhimlal Mato. He is the witness of that will, Your Lordship, tested the testator who has done the will. AW2 is the Sade Mahato, the applicant. The following documents have been marked exhibit on behalf of the applicant, which are as follows. Exhibit 1 is the will of Ravi Mahato dated 2nd of September 2005, and Exhibit 2 is the signature of AW1 Bhimlal Mahato on the will. The opposite party have examined altogether two witnesses in this case. That is the opposite party number 1, Stish Mahato, and the opposite party number 2, Mandu Devi alias Mahatain. The opposite parties have been brought on record one document for marking the same as exhibit. That is, Exhibit A is the certified copy of the order dated 1st of September 2005 to 27th of October 2005 of consumer case number 251 of 2005. AW2 is the Sadeh Mahato, who has stated that he is the applicant of the case. He has further stated that his elder brother Ravi Mahato was issueless, and the first wife of Ravi Mahato died, and his second wife, who is the opposite party number 1, left her husband about 17 years ago. He has further stated that he looked after and maintained his brother. He has further stated that on 2nd of September 2005, Ravi Mahato executed a will before the registration office Dhanbad, and he had given all his movable and immovable properties, out of which householding, land, and the money kept in the bank, to him through his will. He has stated that the Ravi Mahato put his thumb impression in the presence of witness Bhimlal Mahato and Chandi Charan Pal and him. Bhimlal Mahato and Chandi Charan Pal put their signatures as witnesses upon the will. He has further stated that Chandi Charan Pal was the attesting thumb impression of Ravi Mahato on every page of the will. He has also stated that Ravi Mahato died on 15th of September 2005. He has further stated that Ravi Mahato had told his counsel to prepare a will, and he had written all the matters as stated by Ravi Mahato. He has stated that Ravi Mahato was suffering from paralysis due to which his hand was trembling. Hence, told not to put his thumb officer told his to put his thumb impression. He has further stated that he had filed the will for probate letter of administration. He has stated that Ravi Mahato was in disposing state of sound mind and his hands were trembling due to paralysis. AW1 is Bhimlal Mahato, who is one of the witnesses of the will, who has stated in the examination of chief filed an affidavit that he knows Ravi Mahato, who died. He has further stated that on 2nd of September 2005, Ravi Mahato prepared bequeathed a will in the name of Sadem Mato, and he put his thumb impression on each and every page of the will in his presence, and his signature was attested by Chandi Charan Pal, and he also put his signature. He has proved the will on 2nd of September 2005, which has been marked as Exhibit 1. He has also identified his signature upon the will, which has been marked as Exhibit 2. In his cross examination, he has stated that the Ravi Mahato told him about the will before 4 years ago, and he came to him about 2-3 days before preparation of will and told him to go for preparation of will. He has further stated that at the time of preparation of will, Shri S.C. Chatterjee was appointed and he prepared the will in the registry office. He knows the advocate Shri S.C. Chatterjee. He also stated that he cannot say as to which date the will was prepared. He has further stated that he had not read over as to which was typed in the. He has stated in para 43 that his signature was obtained at the courtyard of the registry office paper, and the will was in 2 pages upon which he has put his signature. He has further stated that Sadeh Mato has not put his signature in his presence. Only Sadeh and Chandipal put signatures, again told that Ravi Mahato put his thumb impression. But in para 47 of his cross examination, that he put his signature inside the registry office. Then Chandipal put his signature.
What
Then
is the
Ravi
date?
Mahato put
What is the
his,
date of the will?
Date of will is 2nd September 2005, Your Lordship.
5.
Yes, Your Lordship.
Come
And he
to,
died on 15th of September 2005.
come to internal page 11.
Internal page 11. Yes, Your Lordship.
Para 8, Roman 3.
Yes, Your Lordship. In the case, the will, Exhibit 1,
Yes, read that. Read para 8.
para 8.
First para.
In this case, para 8, Your Lordship. In this case, the will, Exhibit 1, is a registered document. The execution of deed is a prima facie established, but it is very pertinent to see as whether the executor, Ravi Mahato, was in disposing state of mind at the time of execution of the deed or was in a vegetative state of mind. Now, here, Your Lordship, the London Court below is relying on the certified copy of the Consumer Court, where it has been said that
Absolutely.
yes, Your Lordship. But Your Lordship, he has sworn the will before the registry. It's a registered document, Your Lordship. He went
Yes,
before the registry. But
just
there
read,
in
read.
the Exhibit A is the certified copy of the order sheet of the District Consumer
The
Forum,
will is dated, Mrs. Majumdar, the will is dated 2 5
2nd of September 2005.
9 2005.
Yes, Your
Come,
Lordship.
come to Roman 3 on 23 8 2005.
Yes, Your Lordship.
That means before the will was executed, this person was taken to the consumer forum, and the consumer forum has recorded his demeanor and has
That he was-
found that he was deaf, dumb, and no sense of deciding good or bad.
Yes, Your Lordship. That was on 23rd of
After
August.
get the back now, come back at para 7. Your
Para
witness,
7.
who is the only attesting witness, he says the will is of 2 page, but factually the will is of 5 page.
Yes, sir.
So how do you expect that this witness is to be believed? Finished. If there is a doubt, it has to be thrown.
But
set
Your
aside.
Lordship, this will is
But
before the registrar. It is a registered will, Your Lordship.
Registered will doesn't mean that everything it's
Yes, it is a registered will, Your Lordship. And although the
Let's this case on 24th 24th of March. The for further hearing, but in fact, this was on 24th of March. First up, the lower court records of letter of administration case number 6 of 2006, disposed of by District Judge Dhanbad, be called for through special messenger in the meantime. 24th of final.
oblige.
The further hearing. Yes. Any matter?